grab me.
Well, we're telling you, giving you a lawful order. If you don't get out, you're about to get ripped out of the car.
Well, go ahead.
So don't.
I got a back problem. Don't rip me out.
I'm not trying to do that. So come on out. Come on out. We'll explain it to you.
We're gonna tell you, dude. Come on, step out of the car.
Let me go.
No, I'm not letting you go.
Bro, let me go,
This is your last
bro.
chance, man.
No.
Get the fuck out.
Get out.
Get on the ground. Get on the ground. Get on the ground.
Hands behind your back.
In August, a 42-year-old black grandfather in Summerville, South Carolina, drove away from his relative's home and within minutes was grabbed by the throat, punched in the face, and arrested.
Hold him up. Up in the trunk.
If you got your camera, put it in my face.
We got a camera, bro.
The package that supposedly justified the stop, it was still sitting on the porch where the police had left it. Not in his car, not in his hands. On the porch. This episode covers unreasonable traffic stops, excessive use of force, unlawful vehicle searches, and the constitutional protections that were violated at nearly every stage of this encounter. We will walk through each one carefully because what happened to Timmy Miles is not just an outrage. It is a legal education. Before we go further, if you are watching this and you care about understanding your rights and holding law enforcement accountable, subscribe now and hit the notification bell. This channel exists to give you the legal knowledge to protect yourself and your community. Share this video. Knowledge is the first line of defense. To properly analyze this encounter, we must first understand the operation that preceded it. Law enforcement agencies frequently employ a tactic known as a controlled delivery. Charleston police had intercepted a FedEx package containing marijuana addressed to a residence in Somerville. The package was addressed to an individual who did not reside there, and Timmy Miles, who was visiting the home to see family, had no knowledge of it. Officers from the Somerville Police Department delivered the package to the front porch of the residence and stationed surveillance officers in a wooded area nearby to observe who would take possession of it. This is a lawful and established investigative technique. The legal theory is straightforward. Whoever knowingly takes possession of a package containing contraband can be charged with receipt of that contraband. However, the operation's integrity depends entirely on officers maintaining continuous and reliable observation of the package. That did not happen here. The officers lost sight of the package. At roughly the same time, Timmy Miles left the residence. Corporal Robert Barano concluded without any confirmatory evidence that Miles must have picked up the package. That conclusion, drawn without a single piece of articulable evidence, became the basis for everything that followed. The Fourth Amendment to the United States Constitution protects individuals against unreasonable seizures. A traffic stop constitutes a seizure under the Fourth Amendment, and to be constitutional, it must be supported by at least reasonable suspicion, a standard established by the Supreme Court in Terry v. Ohio in 1968. Reasonable suspicion requires that an officer be able to point to specific, articulable facts that, taken together with rational inferences, reasonably suggest that criminal activity is occurring. Critically, it is an objective standard, meaning a court will ask not merely what the officer believed, but whether a reasonable officer in the same circumstances would have held that belief. Here, the only basis for stopping Timmy Miles was that officers had lost sight of a package and Miles had left the property around the same time. Miles had not been seen picking up the package. No surveillance footage captured him taking it, no officer witnessed him handle it. The package, as it would turn out, had never moved. It was still on the porch. Under these circumstances, Miles would have a strong argument, and his attorneys did make this argument, that the traffic stop was not supported by reasonable suspicion and was therefore unconstitutional from the outset. The Supreme Court held in Pennsylvania v. Mims in 1977 that officers may order a driver to exit a vehicle during a lawful traffic stop as a matter of course without requiring any additional justification. This was extended to passengers in Maryland v. Wilson in 1997. However, and this is critical, the lawfulness of that order depends on the lawfulness of the underlying stop. If the stop lacks reasonable suspicion, the order to exit may itself be unlawful, and a defendant could potentially argue they were not required to comply. That said, courts have generally been reluctant to extend the right to resist even unlawful police orders, particularly in the Fourth Circuit, which governs South Carolina. Section 16-5-50 of the South Carolina Code limits the hindering statute to interference with arrests. However, A Somerville municipal ordinance makes it unlawful to refuse to obey a lawful order of any police officer engaged in official duties, giving Miles a potential defense if the underlying stop was unlawful. Now, assuming for the sake of analysis that the stop was lawful, what level of force may an officer use to remove a non-compliant driver? The Fourth Circuit addressed this directly in Armstrong v. Village of Pinehurst in 2016, holding that non-compliance with lawful orders justifies some use of force, but that the level of justified force varies based on the risks posed by the resistance. The distinction between active and passive resistance is central here. In the 2022 case of Nazario versus Gutierrez, the Eastern District of Virginia held that verbal refusal to exit a vehicle constitutes purely passive resistance. Timmy Miles verbally refused to exit. He expressed confusion and asked for an explanation. He made no threatening movements. He did not attempt to flee. He was, by every observable measure, passively resistant. The Fourth Circuit has been clear that passive resistance does not justify severe force. In the 2020 case of Wilson versus Painter, the court denied qualified immunity to an officer who delivered a single closed-fist strike to the face of a driver who had failed to comply with 4 consecutive orders to exit his vehicle, noting that the driver had made no threatening or evasive movements and that the officer had blocked the door. In a 2021 appeal, the Fourth Circuit affirmed that denial. Barano waited approximately 35 seconds before using force, slightly longer than the officer in Wilson, but used significantly more force. He grabbed Miles by the throat, choked him, and punched him at least twice in the face. The department's own separation documentation stated that there was no apparent imminent threat, that Barano's conduct was not objectively reasonable, and that it violated both departmental policy and state law. Another detective was observed grabbing Barano's arm in what appeared to be an attempt to prevent further strikes. Under these precedents, Miles has a strong constitutional claim that the force used against him was excessive and unreasonable. After Miles was removed from his vehicle, officers discovered that the package was still on the porch. The basis for the stop had evaporated. At that point, continued detention of Miles in handcuffs raises serious Fourth Amendment concerns. A seizure must be justified at every moment of its duration. Once the justification for a stop disappears, continuing to detain someone requires independent justification. The officers had none. Rather than releasing Miles, they requested a canine unit. The Supreme Court addressed canine sniffs in 2 key cases. In Illinois versus Cabales in 2005, the court held that a dog sniff conducted during a lawful traffic stop does not constitute a Fourth Amendment search. However, in Rodriguez versus United States in 2015, the court clarified that officers cannot extend a traffic stop beyond the time reasonably needed to address the original purpose of the stop in order to conduct a dog sniff absent independent, reasonable, articulable suspicion of additional criminal activity. Given that the basis for the original stop had already collapsed, and given that Miles was being held well beyond any reasonable traffic stop duration, the extension of his detention to await the canine unit is constitutionally problematic. The canine arrived and conducted a free air sniff of Miles's vehicle. It did not alert. Despite the negative canine alert, despite Miles's explicit and repeated denial of consent, and despite the absence of probable cause, officers proceeded to conduct an extensive search of Miles's vehicle opening notebooks, folders, and containers throughout the car. The Fourth Amendment generally requires a warrant before officers may search a vehicle. Courts have recognized several exceptions, the most relevant of which is the automobile exception, established in Carroll versus United States in 1925 and refined in Pennsylvania versus LeBron in 1996. If a vehicle is readily mobile and officers have probable cause to believe it contains contraband, a warrantless search is permissible. While the Fourth Circuit held in United States versus Sheets in 2002 that the odor of marijuana can provide probable cause to search a vehicle, there is no precedent establishing that a driver's admission to personal marijuana use without any evidence connecting that use to the vehicle, and in the absence of a canine alert, constitutes probable cause to search. Officers appeared to rely on Miles's admission as their justification. That justification almost certainly would not survive judicial scrutiny, particularly given that the canine had already sniffed the vehicle and found nothing. The search of Miles's vehicle was, in all probability, unconstitutional. Miles was originally charged with possession with intent to distribute marijuana and disobeying a lawful order. Both charges were dismissed, the drug charge dismissed in January of the following year, less than 5 months after the incident. Barano was terminated from the Somerville Police Department. He was subsequently arrested and charged with third-degree assault and battery. A judge found him guilty after a bench trial, sentencing him to time served. Miles filed civil rights lawsuits in both state and federal court. The state case was voluntarily dismissed. The federal case filed under case number 222, CV02789, was terminated in May of 2024, consistent with a settlement. Legal analysts estimated the potential value at over $1 million. No other officers involved in the incident were disciplined, not those who witnessed the force, not those who conducted the unlawful search, and not those who continued Miles's detention after the basis for the stop was proven false. The officers involved in this encounter receive an F, not solely for Burano's violence, but for a collective failure of judgment, integrity, and constitutional adherence that ran through every stage of the encounter, from an unjustified stop to an unlawful search, to a pattern of conduct that can only be described as an attempt to manufacture justification for harm already inflicted. Timmy Miles demonstrated a clear understanding of his rights, particularly his Fourth Amendment right to refuse consent to a vehicle search, which he exercised loudly and persistently. He receives high marks for that. However, in practical terms, citizens in similar situations may be better served by complying with officer orders in the moment, while clearly stating their objection for the record and pursuing legal remedies afterward. The courtroom, not the roadside, is where these battles are most effectively won. Understanding your rights matters. Knowing the law matters. And documenting every second matters. If this video helped you understand what happened and why it matters, please subscribe and share this video. Every view is a person who now knows more about their rights than they did before. That knowledge belongs to everyone, but it matters most in communities that have been systematically denied it. We will see you in the next episode.
On the ground! Get on the ground! Do you not listen? Get on the ground! Get on the ground! Get on the ground! Hey, let me see your hands. Bert, get on the ground! Get on the ground! Get on the ground right here! Get on the ground! You, Burgundy shirt, get on the ground! Over here! On the ground! On the ground! Get on the ground! Do you not listen? Get on the ground! Get on the ground! Get on the ground! There's a gun behind me. There's a gun, I believe, behind me.
I ain't got no gun, nothing.
Put your hands behind your back. Is there a gun back there?
Ain't no gun.
By that truck.
Ain't no gun.
You're not listening, dude. Bro, you got a gun on you, man?
No, I ain't got no gun. I
I'm
don't
just
want no gun. I don't
Turn
want
back over. Paul, do you watch him say? He had something.
I ain't want no gun.
The door's unlocked, it's not always so.
No, he was right here. Watch him. Go watch him. There it is.
I don't want no gun.
All right, that's what he had. All right, who's the complainant? All right, get him up.
Put the leg up.
25 city, got one chain.
Alright. Put the leg that way so you can stand up.
All right, listen, I'm about to help you. Hold on. Hold on. All right, ready? 1, 2, 3. All right.
Yep.
Listen.
Yep, they slammed my head
Listen.
down on the cement. Yep.
Go back inside. Go back in the house. Go back in the house. Ain't nobody talking to you.
I got head trauma.
Go back in the house.
Yep. Y'all bust my head down. Yeah, I've been in an accident. Yep. Y'all bust my head down. You threw me down.
I sure did.
And
You wasn't listening.
Yep. No, it ain't. You ain't to throw me down like that. I'm disability.
Okay.
I got head problem. Yep. You threw me down. Yep. You throw me down. You throw me down. Yep, you bust my head down on the cement. Yep, you bust my head.
All right, let me tell you what happened.
His forehead.
You bust my head down on the cement.
He was in front of the car when I came up. And he was walking like this. And I thought it was a gun at first. I said, drop the gun, drop the gun, drop the gun, drop the gun. I had him at gunpoint. And he's over here doing something like this.
You slammed my head. You slammed my head.
What he was doing is putting this up behind the tire. So he comes over right here. He got his hands in his pockets. I tell him, let me see your hands, let me see your hands, let me see your hands.
My head?
He wasn't listening.
No, it ain't.
He got the, like this right here,
You grabbed me.
and we went onto the ground.
You bust my head down
That's what
on the cement. You bust my forehead.
Yeah, your head dig it, hit the cement.
Damn right, because you bust me down on the cement.
Where's the complainant?
You bust my head down on the cement.
Right here?
You bust my head. You bust my head.
Where's the complainant?
You bust my head down.
We're trying to get the name of the complainant.
You
So,
bust my head. You bust my head down on the cement. If you ain't nobody who got no. You bust my head down. Hell no. Yeah, bro. I'm my bitch, you don't. Then we had dinner. Anybody had no gun. I live right there. Ain't nobody had no gun. I ain't got no more phone. I ain't got nothing to use.
Putting your change right in your pocket.
Damn right. You slam me, you slam my head down.
What are we doing? Guess Sam was going to check him out.
There
ain't nothing about here on the press charges on.
Who called?
I'm not sure.
Take him out of cuffs right now. I mean, because that's what we got.
You're going to have to use your force.
Yeah.
No doubt.
Yeah.
slam my head down.
Dude, I didn't know what his intention was.
You need to have a look at the camera.
The officer did wrong. Slam my head down. Bust my forehead. Damn right. You're going to pay me for that.
Mayor, I'm going to take that in the evidence of what he had.
What?
Well, I mean, you know, that's the reasons I did what I did. You know what I'm saying? That's where I'm coming from. Because when he was behind the truck, I couldn't see what he was doing. And I didn't know where that went. If it was still in his pockets when he come around that car with his hands in his pockets.
His dogs on.
On camera.
Yeah, my dog
That's fine.
A dog stick.
So he can come out of cuffs?
Yes. Take him out of handcuffs.
Yeah, he can come out.
Oh, Lord.
You mind looking? Hi. Good, how are you? What's going on?
Officer slammed my forehead down in the cement.
Okay.
In the wrong place.
Consciousness?
Yeah. Can I get a card from you?
I don't have one now. We don't have one. They don't give us cards.
Okay, what's your badge number?
1059.
Let me see if I can get my phone. Hold on.
Hold on. We have cards. Okay. Thank you.
Yeah.
Brandon, he can get this stuff off the car.
Dukes, will you say badge number?
1059.
On the 26th day of July, 2021, in Orangeburg, South Carolina, just after 5 o'clock in the afternoon, two men were doing something completely ordinary. Clarence Gayard, 58 years old, and his cousin Demario Julian were walking home. That is the entire story of what they were doing. Not running, not hiding, not causing trouble. Walking home on a summer evening in their own neighborhood. They never made it home without incident. Somewhere nearby, a call came into 911. Someone reported a man with a gun. Officers were dispatched to the Colleton Village townhomes, and when Officer David Lance Dukes stepped out of his patrol vehicle, he had already drawn his weapon before he had assessed a single thing about what he was actually looking at. What he was looking at was a 58-year-old man walking with a stick, not a firearm. A stick wrapped in shiny silver tape that Clarence Gayard carried everywhere he went, not as a weapon. As protection against the aggressive stray dogs that roamed his neighborhood. This was a man navigating his daily life with a makeshift tool, and Officer Dukes, gun already out, decided in a split second that it was a threat. Here is what Dukes did not know or did not bother to find out before escalating. Clarence Gayard does not move quickly. Years before this afternoon, he was struck by a vehicle while riding his bicycle. The impact left him with surgical rods and pins in his leg, his knee, and his hip. He walks slowly. He has no choice. His body will not allow anything else. None of that mattered to Officer Dukes. Before we get into this, hit subscribe and turn on notifications because stories like this one disappear fast. And I refuse to let that happen on this channel. Dukes ordered both men to the ground at gunpoint. Demario Julian, Clarence's cousin, complied, immediately dropped without hesitation. Clarence tried. He was doing his best. He was on his hands and knees, lowering himself toward the concrete as fast as his damaged body would allow. Anyone watching the body camera footage could see a man making every visible effort to follow the command. That was not fast enough for Officer Dukes. What happened next is on camera. Dukes approached Gayard while he was in that defenseless position, hands and knees on the ground, raised his right boot, and stomped down on Gayard's neck and head. The force drove Clarence Gayard's head into the concrete of the parking lot. A 58-year-old disabled man, on his hands and knees, attempting to comply. And an officer in full uniform brought his boot down on his skull. Clarence Gayard was taken to hospital. He left with a contusion to his forehead and a scar that would remain visible for weeks. Whatever that moment leaves inside a man, the kind that no medical report has a category for that went home with him too, here is where it gets worse. When Dukes cuffed Gayard and brought him to his feet, Gayard, head bleeding, said, "Y'all bust my head down. You throw me down." Dukes responded, "I sure did. You weren't listening." Not regret, not concern, not the reaction of a man who understood he had crossed a line that should never have been crossed. Certainty. Almost satisfaction. "I sure did." Then Dukes walked over to explain himself to his supervisor, and what he told that sergeant is one of the most remarkable moments in this entire case. He said Gayard had a stick, and he thought it was a gun. He said Gayard failed to comply. He said both he and Gayard simply went to the ground together. He did not mention the stomp. He described a man who fell, not a man whose head he had driven into concrete with his boot. He stood there and lied. His colleague, Sergeant Aquil Polidore, was standing right there. Her body camera caught everything, and when Dukes finished his version of events, Polidore looked directly at the supervisor and said, "He is not telling the truth." Dukes kicked Mr. Gayard in the neck. In her written report, Polidore noted she had asked multiple times whether Gayard needed medical attention. Neither Dukes nor the other officer answered her. She wrote that she was in disbelief over what she had witnessed. Sergeant Polidore did not look away. She did not close ranks. She told the truth, on camera, in writing, while Dukes was standing right there. That deserves to be said clearly and remembered. Let us pause and examine what was happening legally in that parking lot. Under the Fourth Amendment of the United States Constitution, all citizens are protected from unreasonable seizures, including the use of excessive force by law enforcement. The legal standard, established by the Supreme Court in Graham versus Connor in 1989, requires that force used by an officer must be objectively reasonable based on the circumstances as they appeared at the moment, not in hindsight, but in the moment. The relevant factors are the severity of the crime suspected, whether the suspect poses an immediate threat, and whether the suspect is actively resisting or fleeing. Apply those factors here. Clarence Gayard was suspected of nothing more than possibly carrying a weapon based on a single unverified 911 call. He posed no immediate threat. He was on his hands and knees. He was not resisting. He was actively, visibly attempting to comply. There is no reasonable reading of Graham versus Connor under which stomping on the head and neck of a man already on the ground constitutes lawful force. The department's own investigators agreed. The duty captain described Dukes' use of force as excessive. The internal report formally documented that Dukes' account was inconsistent with the body camera footage, a written finding, from inside his own department that he had lied in his official report. That is not an allegation. That is a documented institutional conclusion. 2 days after the incident, Orangeburg Department of Public Safety Chief Mike Adams terminated David Lance Dukes, stating publicly that his actions fell outside the department's use of force policies. The case was then referred to the South Carolina Law Enforcement Division for criminal investigation. SLED determined that Dukes' actions were likely to produce death or great bodily injury. On July 31st, 2021, 5 days after the Stomp Dukes was arrested and charged with first-degree assault and battery, he was booked into the Orangeburg County Detention Center and released on a $10,000 bond. If convicted, he faces up to 10 years in prison. The criminal case is still working through the courts. In November of 2021, the city of Orangeburg reached a $650,000 civil settlement with Clarence Gayard. The city issued a formal apology and committed to establishing a citizens' task force for oversight of law enforcement interactions with the public. Gayard's attorney, Justin Bamberg, noted he had rarely seen a city accept responsibility so quickly and work so visibly to prevent recurrence. Now here is the part of the story that the press releases left out. David Lance Dukes had a history. According to records from the South Carolina Criminal Justice Academy, he was originally hired by the Calhoun County Sheriff's Office in 2012, but was removed because he could not pass the mandatory academy test. He rejoined the force a year later. By April of 2020, his supervisor documented that Dukes was causing turmoil within the unit, creating a hostile work environment, and was counterproductive to the goals and mission of the department. That same supervisor had personally counseled Dukes on his behavior and conduct at least 6 times. In October of 2020, Dukes was fired from the Calhoun County Sheriff's Office for insubordination. 9 months later, he was standing in a parking lot in Orangeburg with a badge, a gun, and his boot on a man's head. A department hired him anyway, gave him a uniform, sent him into a community where 75% of residents are black, and when that community called 911 a call placed, it later emerged by a relative of Gayard who said she had never actually seen a gun and declined to press any charges. David Lance Dukes was the response they got. From a legal standpoint, this raises the question of negligent hiring, a civil doctrine that holds employers liable when they hire individuals they knew, or should have known, posed a foreseeable risk of harm. If an employer can be held liable for ignoring an employee's documented problematic history, the same principle applies to law enforcement agencies. Orangeburg did not create Dukes' record, but someone reviewed it and decided it was not disqualifying. That decision has consequences, legal, moral, and human. This is not unique to Orangeburg. Across the United States, a well-documented phenomenon exists where officers with misconduct records move between departments, sometimes called gypsy cops in policy literature, because no centralized, mandatory functional system exists to flag and prevent that movement. The paper trail was there, the system just did not act on it. After the settlement, after the cameras, after all of it, Clarence Gayard stood up and said something worth sitting with. Every time I look in the mirror, I see the scar on my forehead and it is not okay. The only thing I want the community to do is change. He did not call for destruction. He did not ask for vengeance. He asked for change from a man who had just had his head driven into concrete by someone who was supposed to protect him. And he said this about Sergeant Polidor, the officer who told the truth. She didn't lie. She told the truth. All officers are not bad. Some are good. He said that. After everything. David Lance Dukes was fired. He was charged with a felony. A $650,000 settlement was reached on behalf of the man whose head he put into concrete. His previous employer had documented his failures in writing 6 documented counseling sessions, a hostile work environment finding, a termination for insubordination, and none of it stopped the next department from handing him a badge. That last part does not have a resolution yet. Clarence Gayard was trying to get to the ground. He was doing exactly what he was told, at the only speed his broken body allowed. And an officer already fired once, already counseled 6 times, already flagged in writing as a problem decided that was not good enough. The scar on Gayard's forehead is still there. The criminal case is still pending. And somewhere in South Carolina, there is a hiring process that looked at David Lance Duke's full record and said, yes, anyway, that process has not been fixed. Not here. Not in enough places. Until it is, what happened in that parking lot on July 26th, 2021 will keep happening. Somewhere else. To someone else. By someone whose paper trail was already writing the ending long before any body camera ever rolled? Drop your thoughts in the comments. Share this if it reached you. Subscribe if you want to stay with stories like this one.
Last time! Drop the knife! Drop it! Fuck!
Oh my God!
Hey! Hey, drop the knife! Drop the knife!
You have a taser?
No, drop the knife! 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 Woman, you're gonna get shot! Drop the knife! Drop the knife! Drop the knife! Drop it! Last time! Drop the knife! Drop it! Fuck! Fuck!
Any of the units able to free up, head over to 687 Blue Hills Ave. Just need one more car, head over to 687 Blue Hills Ave. Shots fired, 687 Blue Hills Ave, shots fired. Officer involved, 687 shots fired, 687 Blue Hills Ave.
We did things with my man.
Fuck you ain't changed that man for? Nah, fuck you mean with that, bro? The fuck you mean you hit that dude head? Yes, you did, bro. You can't do it like you're fucking happening. Fuck out of here, bro. Stop that fucking dumbass shit, bro.
Drop the knife! Hold on, we have him at gunpoint. He has a knife in his hand. Drop the knife. 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 Craig, just back up. Drop the knife. Just drop the knife. Drop the knife! Drop the knife! Drop the knife! Drop the knife! Craig, just back up a little bit. Drop the knife! Drop the knife! Drop the knife! Drop the knife! Craig, just back up, back up, back up. Craig, drop the knife! Stevie, you gotta drop the knife. We do not want to shoot you. Just drop the knife. Drop the knife! Drop the knife, hon. Drop the knife. Drop the knife! Honey, you gotta drop the knife. You gotta drop the knife. Still hasn't let go of the knife. Drop the knife! Drop the knife, hon. Back up, hon. Just back up a little bit. Stevie, you gotta drop the knife. You gotta drop the knife. You gotta drop it, honey. Drop it, hon. Drop it. It's not that, hon, we don't have to do that stuff. Can we, do we have another taser?
Okay, can you drop it for me, Steve?
Do we have anyone else with a taser?
Steve, can you drop it? Come in. What's going on with you?
Honey, you gotta drop the knife.
Drop it. Just drop it so we can help you. You got a big knife in here. You gotta drop it so we can help you.
Please just drop the knife, hon.
All right, Steve? Steve, you're okay. We're gonna make sure you're okay. Just
drop the knife. Come on.
We're gonna go talk to somebody, okay?
Drop the knife, hon. Do you have a taser? Do you have a taser?
No, drop the knife. Drop the knife. Drop the knife.
Stevie.
Drop the
Mag.
Drop the knife.
Mag, just back.
Drop the knife.
Mag.
Drop the knife.
Drop it! Stevie!
Last time. Drop the knife. Drop it.
You gotta drop it. My man, you gotta drop it. You gotta drop it. We don't want to shoot you. We don't want to, bro. You gotta drop it. Drop it. You don't want to get shot. You don't want to get shot. Come on. Drop the knife. We don't want to do that. Can you just drop the knife for me, my man? Just drop it. Just drop it. Just drop it. My man, you don't want to get shot. Think about it. Drop the knife. We're just going to get your help. We're going to get your help. Just drop it. Just drop it. My man, we're good. Yo, look at me. Look at me. We're here to help you. We're here to help you. Just drop it. Just drop it. We're just going to get you to the hospital. We're going to talk to somebody. Your family wants you to get help. What's your name, my man? What's your name? What's your name? Stevie. What's his name? Stevie? Stevie, can you drop it for me? Stevie, you gotta drop it. You gotta drop it, Steve. You got. Stevie, you gotta drop it. You gotta drop it. You gotta drop it. You gotta drop it. Stevie, watch that.
Stevie, drop the knife. Come on, baby.
Stevie, you're okay. Stevie, look. They're trying to help you. They're trying to help you.
Calm down, Stevie.
They want to help you. Just drop it and we'll help you.
You ain't hungry?
Stevie, drop it. Drop it. We're going to put the guns away and that's it.
It's me, Nate. Me and Derek. You going to send me. Drop the knife.
Stevie, just drop it. Just drop it. It's all done, Stevie. It's all over with, Steve.
Stevie, come on.
Steve,
You gotta drop the knife.
Stevie,
You gotta
come on.
drop the knife. You gotta drop it, honey.
Get Sonny, Stevie. Come on.
Drop it, hon.
Stevie, it's over with. It's over with. Just drop it and let's go get help. All right?
It's not that. You don't have to do
Stevie,
that.
drop the knife.
Stevie, you're okay.
Do we have another taser?
You're okay. Can you drop it for me, Steve? Stevie, can you drop it, my man? What's going on with you? Drop it. Just drop it so we can help you. You got a big knife in your hand. You got to drop it so we can help you. Okay? All right, Steve? Steve, you're okay. We're going to make sure you're okay. Just drop the knife. We're going to get you. We're gonna go talk to somebody, okay? Stevie, just drop it. Just drop it.
Drop the knife.
Stevie, Mac, chill. Stevie, Magnano, chill. Stevie, you gotta drop it.
Last time.
Stevie, drop it.
Drop it.
That's fine. Keep it nice.
Hold on, drop the knife. Drop the knife first. Have him drop the knife. What's his? Hey, throw the knife away. Throw the knife. Drop. All right, he's coming toward you. Drop the knife. Drop the knife. Yep. I'm not gonna shoot him. Drop the knife. Drop the knife. Drop the knife, please. Drop the knife. Drop the knife. I'm just creating distance. Drop the knife. Taser.
Relax. Hey, you gotta drop the knife. We don't want to shoot you. You gotta drop it.
Shit is ineffective.
You gotta drop it. We don't want to shoot you.
Drop the knife. Drop the knife. Drop the knife! Drop the knife! Stevie! Drop the knife! Stevie! Stevie! Yo, Stevie! Drop the knife! Hey! Stevie! Drop the knife! Come on, baby! Come on!
Drop the knife! Look, Stevie, look. Let's do this for 2 cheese of bacon. Calm down, Stevie. Stevie,
Drop the knife!
you ain't hungry?
Stevie, drop it.
You gotta drop the knife!
Stevie, it's me and Nate. Me and Derek, we go get something to eat. Drop the knife. Come on, man.
Stevie, come on, drop the knife!
Come on, Stevie.
You're good.
Come on, you want something to eat?
Good job, Stevie.
Stevie, come on. Drop the knife.
Stevie, come on. Yeah, get something to eat, Stevie. Just drop the knife, Stevie. Okay? Stevie, drop the knife.
You okay? Can you drop it for me, Steve? Steve, can you drop it? Come in. What's going on? I got one more here. We're gonna make sure you're okay. Just drop the knife.
Drop the knife, Stevie.
We're gonna go talk to somebody, okay? Come on, Stevie.
Stevie, drop the knife, all right?
Drop the knife. Drop the knife.
Stevie!
Drop the knife. Drop the knife.
Stevie!
Mama, you're gonna get shot. Drop the knife.
Steve!
Drop the knife.
Stevie!
Drop
Stevie!
it. Last time.
Stevie!
Drop the knife. Drop
Stevie!
it.
On February 27th, 2026, a woman made a phone call. She was not calling to report a crime. She was not calling because she was afraid of her brother. She was calling because she loved him, because she could see he was struggling, because she believed, the way families are supposed to believe, that the system would send help. Her name is Audrey Jones. Her brother's name was Stephen Jones. Everyone who knew him called him Stevie. Stevie never came home. And before this video is over, you are going to understand exactly how a sister's call for help became a death sentence. You are going to understand the law, the failures, the pattern, and the people who are still fighting for answers. If you have not seen my last video about Everard Walker, I will leave it linked in the description, because what happened to Stevie Jones did not happen in isolation. It happened 8 days after Everard Walker was killed in his own apartment on Capitol Avenue. 8 days. Same city, same crisis, same outcome. 2 black men, 2 families that did the right thing. 2 funerals. But today we are talking about Stevie. Before we get into it, if you are new here, subscribe and turn on notifications. We cover stories like this every single week, and you do not want to miss what is coming. Now, let us get into it. Stephen Jones was 55 years old. He lived in Hartford's North End on Blue Hills Avenue. He was known in his community as Stevie, a name that carries warmth, the kind of name people use when they genuinely love you. His sister Audrey described him simply. He was a good person. He was always there for everyone. He was a good brother to me. That is who was standing on that front stoop on the morning of February 27th. Not a criminal, not a threat. A 55-year-old man who was not well, whose family could see it, and whose sister made the hardest kind of decision a family member can make. She called for help. Audrey Jones dialed 911 on the morning of February 27th, 2026. She reported that her brother was experiencing an acute mental health crisis. She told them he had not taken his medication. She was present. She was trying to get him care. Now I need to pause here because I covered this in my Everard Walker video, and I need you to carry that context into this story. Hartford had a program, a real one. The Hartford Emergency Assistance Response Team, the HERE team, was specifically designed to send social workers and peer responders instead of police to exactly this kind of call. The city spent $5 million building it. It had handled over 2,000 calls since 2022. It existed so that a family like Audrey's would not have to pray that the people who showed up at their door would choose care over force. But by January 2026, that program had already been quietly gutted. Weekend coverage eliminated entirely. Evening hours cut. A key partner organization dropped. Federal funding had dried up and the city had not replaced it. So when Audrey called 911 on that Friday morning, the full safety net that should have caught her brother was already fraying at the edges. What arrived instead was police. Officer Josue Charles arrived first. He found Stevie Jones on the front stoop of his apartment holding a knife. He immediately ordered Stevie to drop it. Stevie walked slowly toward him. Officer Charles deployed a taser. It was ineffective. And then Officer Charles said something to Audrey Jones that I want you to hold on to. He looked at her and said, "I am not going to shoot him." Read that again. The first officer on scene, facing a man with a knife, made a choice. He made a promise. I am not going to shoot him. Officer James Prignano arrived next. He kept talking to Stevie. He told him, "We don't want to shoot you. We don't want to, brother. We're just going to get you help. We're here to help you. Just drop it. We're just going to get you to the hospital. We're going to talk to somebody. Your family wants you to get help." Officer Jacqueline Torres arrived third. She asked Stevie to drop the knife. She asked if anyone had another taser. She kept the tone measured. She kept working. For 5 full minutes, 3 officers stood in the street with Stevie Jones. They formed a semicircle around him. They called him by name. They told him he was going to be okay. They did not fire their weapons. 5 minutes is a long time when you are afraid. 5 minutes is a long time when you are holding a position and trying to reach someone who cannot reach back. Those 3 officers held that line. And then a 4th officer arrived. Officer Joseph Magnano pulled up to Blue Hills Avenue as the 4th officer on scene. He was 23 years old. He had graduated from the police academy on March 28, 2025. He had been on the job for less than 1 year. He was still inside his probationary period. He had no taser. From the moment Officer Magnano stepped out of his patrol car to the moment he fired the first shot, 32 seconds elapsed. 32 seconds. While the other officers had spent 5 minutes building toward a moment where Stevie might put down that knife, Magnano arrived, pointed his gun, and within 32 seconds made a decision that those 3 officers had spent 5 full minutes refusing to make. The body camera footage shows what happened in those seconds. Officer Torres asked Magnano if he had a taser. He said no. He pointed his weapon at Stevie and ordered him to drop the knife. Stevie walked toward him. Officer Prignano can be seen raising his hand toward Magnano in what appears to be a pause gesture. He called Magnano's name. "Magnano, Magnano," he said. "Torres said it too." Mag. Magnano fired 9 times. Stevie Jones collapsed in the street. Audrey Jones, who had called 911 to get her brother help, who had stood on that street and watched officers try to reach him, screamed. She had told them he hadn't taken his medication. She had begged them not to shoot. "I screamed at the police, 'Don't shoot him,'" she said later. "He didn't take his meds, and they shot him anyway." Stevie was transported to the hospital. He died 4 days later on March 3rd, 2026. He was 55 years old. Now, let me put on my legal hat, because there are several questions this case raises that go beyond grief and outrage into the territory of law and accountability. The first question is the use of force standard. Under Connecticut law and the 4th Amendment of the United States Constitution, a police officer may only use deadly force when they reasonably believe there is an imminent threat of death or serious bodily harm. The legal test is not what the officer felt subjectively. It is what a reasonable officer in that situation would have believed. Here is why that matters in this specific case. 3 officers, all facing the same man with the same knife in the same street, made the determination not to fire. They held that position for 5 minutes. Then a 4th officer arrived and fired within 32 seconds. Civil rights attorney Ben Crump asked the question that the law demands be answered. Why did the other 3 officers not shoot? Why did they have restraint? If the situation legally justified deadly force, why were 3 trained officers exercising a different judgment? That contrast is not just emotional, it is evidentiary. In a civil lawsuit, the conduct of the other 3 officers becomes directly relevant to whether Magnano's use of force was objectively reasonable. You cannot easily argue a threat required lethal force when 3 of your colleagues stood in front of that same threat and chose differently. The second question is experience and judgment. Magnano was less than 1 year out of the academy. A criminal justice expert named Mike Lawler, an associate professor at the University of New Haven who helped shape Connecticut's policing standards, noted that experience matters in high-pressure situations. He observed that the first 3 officers were maintaining eye contact, engaging in conversation, keeping what for them was a safe distance. He said everything changed when the 4th officer arrived suddenly. Magnano's rapid engagement with Stevie, Lawler said, highlights the challenges that arise when a relatively inexperienced officer confronts a volatile scenario. The police union pushed back on this. Union President Sergeant James Rutkowski argued that all 4 officers had their guns drawn, that this was a lethal situation, and that Magnano did what he was trained to do. But that argument carries its own weight. If a less than 1 year officer with 32 seconds on scene, no taser, and no integration with the existing de-escalation effort did exactly what he was trained to do, then the training itself is on trial. The third question is civil liability. Connecticut's Police Accountability Act is one of the strongest such laws in the country. It creates a state-level pathway around qualified immunity, the federal doctrine that has historically made it nearly impossible to hold individual officers accountable in federal court. Attorney Ben Crump confirmed the family was exploring all civil legal options. A civil lawsuit under Connecticut's accountability law would likely center on excessive force and could name both Magnano and the city of Hartford. The city's potential liability would rest in part on questions of training, supervision, and whether the deployment of an inexperienced officer without a less lethal weapon to an active de-escalation situation constituted deliberate indifference to Stevie Jones's constitutional rights. The fourth question is criminal accountability. The State Office of Inspector General was investigating whether Magnano's use of force met Connecticut's statutory standards. The bar for criminal charges is significantly higher than civil liability. A prosecutor would need to prove beyond a reasonable doubt that Magnano did not have a reasonable belief he was in danger. That is a difficult threshold, but the investigation was ongoing and the community was watching. On March 27, 2026, Hartford Mayor Arunan Arulampalam walked out of City Hall and announced that Officer Joseph Magnano had been terminated immediately. He praised the other 3 officers. He said, "What I saw were 3 officers who exemplified the very best of that badge. 3 officers who worked collaboratively as a team to de-escalate a really difficult situation. And then I saw 1 officer come in, Officer Magnano, late to the scene, not work with his teammates, not de-escalate, and the end result of that was a tragic incident that took the life of Stephen Jones." The mayor said Magnano's performance did not meet the standards expected of the Hartford Police Department. Now, here is the legal detail that almost nobody is talking about. That day, March 27th, was the final day of Magnano's probationary period. Under Connecticut law and the terms of the police union contract, the mayor can only terminate a probationary officer based on performance without triggering the full weight of union contract protections. Had the mayor waited one more day, one single day, Magnano would have crossed out of his probationary period, and the union's contractual grievance and arbitration machinery would have made firing him exponentially harder. The mayor used the one window the law gave him, and he used it on the last possible day it existed. That is either decisive leadership, or it is the bare minimum. You can decide which. But understand what it means structurally. The system was designed in a way that gave the community exactly 1 day to get accountability through this particular door, and that door was always going to close regardless of what Stevie's family deserved. The Hartford Police Union did not take the firing quietly. Union President Sergeant James Rutkowski called the mayor a coward. He said the mayor caved to political pressure and was devoid of any semblance of leadership. He said the shooting was a justified, lawful use of force. He said, "We go to war." When asked what that meant specifically, he said, "We'll find out." That is the head of the union that represents the officers who will respond the next time a family in Hartford calls 911 during a mental health crisis. Sit with that. I need you to step back with me now because Stevie Jones's story does not begin on February 27th, and it does not end with Magnano's firing. 8 days before Magnano shot Stevie, Officer Alexander Clifford shot and killed Everard Walker inside his Capitol Avenue home. I covered that story in my last video. Walker's family had called 211, the Health and Human Services line, specifically to avoid a police response. They still got 11 officers. Walker is still dead. And, as of the time this video covers, Officer Clifford remained on duty. He was not fired. 2 black men, 2 families who followed the system's rules, 2 funerals, 1 officer fired, 1 still on the job. The community held the mayor and police chief to that disparity. They issued 5 demands: a public briefing within 7 days, termination of both officers, the Inspector General investigation completed within 6 months, permanent, full funding of the Mental Health Crisis Response Program, full activation of the Civilian Police Review Board. The mayor issued a statement about transparency and accountability. He did not commit to the briefing. He did not commit to firing Clifford. He did not commit to the review board. And speaking of that review board, while the community was demanding its activation, the Hartford Police Union was in the middle of a legal challenge designed to strip it of its power. The union filed a complaint arguing that when the city gave the review board the ability to take misconduct cases to binding arbitration, it violated state labor law. That case was scheduled to be heard by the State Board of Labor Relations in early April 2026. The very mechanisms of accountability that the community was demanding were being litigated out of existence at the same moment the community was demanding them. That is not a coincidence. That is how these systems protect themselves. On March 12, 2026, dozens of community members gathered at the corner of Blue Hills Avenue and Euclid Street, steps from where Stevie Jones was shot. Reverend A.J. Johnson of Urban Hope Refuge Church spoke for them. The pain our community has felt over the last 2 weeks is telling us clearly that our city is in need of care, accountability, and repair. We are not here to inflame the situation. We are here because silence will not heal the wound. Kenneth Green, a former Hartford State Representative and licensed clinical social worker, stood before that crowd and said what needed to be said. Communities need to know that when someone calls for help, the response will be compassionate, professional, and focused on care. That is not a radical demand. That is the minimum that any human being should be able to expect when they pick up a phone and ask for help. Stevie's funeral was held on March 26, 2026 in Bloomfield. Reverend Al Sharpton was there, Ben Crump was there, Mayor Arulampalam was there, and Audrey Jones was there, the woman who made that phone call, the woman who stood on that street and watched what happened to her brother, the woman who said afterward, "If I would have known that they were going to kill my brother, I would not have ever called 911 for an ambulance." Read that again. The sister of a man killed during a mental health crisis is telling the world that she regrets calling for help. That is the damage this does, not just to one family, not just to one community. To every single person who now has to weigh whether calling 911 for a loved one in crisis is worth the risk. That is what was taken from Hartford's North End on February 27th, 2026. Not just Stevie Jones. The ability to trust the phone call itself. Stevie Jones did not die because he was dangerous. 3 officers stood in front of him for 5 minutes and made that determination with their restraint. Stevie Jones died because a 23-year-old officer with 32 seconds on scene, no taser, and no integration with an ongoing de-escalation effort made a different determination. And behind that officer was a system that had already cut the mental health response program that might have meant police never needed to be there at all. And behind that system was a union actively fighting to ensure that when things like this happen, the community has as little power as possible to demand accountability. Stevie deserved a doctor. He deserved care. He deserved the 5 minutes that 3 officers gave him to become more than the worst moment of his crisis. He deserved to walk back into that apartment and take his medication and call his sister and tell her he was okay. He deserved to come home. Say his name. Stephen Jones. Stevie. 55 years old. A good person. A good brother. A man who deserved better from every single institution that failed him on February 27, 2026. If this video moved you, share it. Drop your thoughts in the comments. If you are new here, go watch my Everard Walker video because these 2 stories are one story. And subscribe because this is what we do. We make sure these names are not forgotten. I will see you in the next one.
Here we go. Get down!
I already know it. This one right here.
Boy, get it, get it.
Let her come through. No. No. Because he put his hands on me, so I'm not shutting up. Don't.
February 19th, 2026, Hartford, Connecticut. Sometime before 10 in the morning, a family makes a decision, a hard one. The kind of decision that takes deliberation, that takes trust, that takes courage, because they know what can happen when certain people show up at your door. They do not call 911, they call 211. That distinction is everything. And by the end of this video, you are going to understand exactly why. 53-year-old Everard Walker is inside his 3rd-floor apartment on Capitol Avenue. He is not well. His family knows it. They love him. They want him evaluated. They want a doctor. They want someone trained to handle exactly this kind of moment, to walk through that door and bring him back to himself. What they get instead is 11 police officers. And Everard Walker never walks out of that apartment alive. If you are new here, this channel exists to make sure stories like this one do not get buried. Subscribe, turn on your notifications, and let's get into it. Before we talk about what happened in that apartment, I need you to know who was in it. Everard Walker was 53 years old, a Jamaican man, a father of 6. He had been with his partner, Linda Gray, for 29 years. They would have celebrated their anniversary on February 21st, 2 days after the shooting. His daughter Menon said her father always put his kids first. Always. His brother Charles described a man who was his world. Linda Gray said it plainest of all. Everard was my world. He was my healer. This was not a stranger. This was not a name on a report. This was a man who showed up for his family every single day. Now, here is the context you need about his mental health because it matters to everything that follows. Last fall, Everard Walker had a psychotic episode linked to a laced cigarette, something that happened to him, not something he chose. He was involuntarily hospitalized, and while he was locked away, unable to get to the people he loved, his 29-year-old stepdaughter died of cancer. He missed her death. He missed her funeral. He never got to say goodbye. By February 2026, Walker had run out of his medication. He was struggling. His family could see it. And so they did what a family that loves someone is supposed to do. They asked for help. Now, let me teach you something, because this is where the legal education starts and where the systemic failure begins. 211 is not 911. In Connecticut, 211 is the Health and Human Services helpline specifically designed as an alternative to calling police during a mental health crisis. The state of Connecticut invested $5 million building out its mental health crisis infrastructure, including something called the HEART Team in Hartford, specifically so that a situation like Everard Walker's would not require a police response. $5 million. The family knew this. That is why they called 211 and not 911. Walker's son Jadane made that call. The family told the operator repeatedly, Everard is not dangerous to himself, he is not dangerous to the community, he ran out of his medication. He needs an evaluation, he needs a doctor. They were not calling in a threat, they were calling in a father. 2 clinicians from the Capital Region Mental Health Center were dispatched. 2 trained professionals equipped to handle exactly this. That is, the system working the way it was designed to work. But then, those clinicians made a request. They asked Hartford police to accompany them. And right there, right at that moment, the door opened to everything that followed. If the people specifically trained to handle mental health crises felt they needed police backup to walk into Everard Walker's apartment, what does that tell you about how this city views black men in mental health crisis? Not as patients, not as human beings who need care, as threats that need to be managed. That request changed. Everything. Let me walk you through what happened, beat by beat, because the timeline matters. Officers arrive alongside the clinicians. Walker's son and daughter are present. The clinicians begin speaking with Walker through the open doorway. That is the protocol. And for a while, it works. Nobody is in immediate danger. The situation is tense, but contained. Then, officers attempt to enter. Walker pushes back. Officers retreat, fearing he might throw a pot of boiling water at them. And here is the thing they made the right call. They stepped back. They de-escalated. No shots fired. Nobody hurt. Negotiations continue for nearly an entire hour. Let that sink in. For almost 60 minutes, Everard Walker is in that apartment with his children, with mental health professionals, with police outside his door, and nobody is dead. The situation is being managed. Then, just before 11 in the morning, Walker tries to close his door. His own son, the same son who made the 211 call to get his father help, physically tries to restrain him. Officers decide to re-enter to assist. Inside that cramped apartment, Walker produces a knife. Officers order him to drop it. He does not comply. Officer Giovanni Rivera loses his footing and falls backward. Officer Alexander Clifford fires multiple shots. Everard Walker is struck in the torso, in the neck, in his right arm. He is transported to St. Francis Hospital. He is pronounced dead. From a 211 call to a homicide in 1 hour. Now, let me put on my legal education hat. First, the knife. The family's attorney described it as a ratchet, a 4-inch pocket knife, common in Jamaican culture. And here is what I need you to notice before the investigation was even complete. Before any determination of whether this shooting was justified, the Office of the Inspector General released still images of Everard Walker holding that knife. Why? Who does that serve? It does not serve Everard Walker. It does not serve his family. What it does is construct a narrative, a justification before we even have all the facts. That is a tactic. Recognize it. Second, use of force law. Under Connecticut law and the Fourth Amendment of the United States Constitution, deadly force by a police officer is only legally justified when the officer reasonably believes there is an imminent threat of death or serious bodily harm. The key word is reasonable. 11 officers. A cramped third-floor apartment. One man with a 4-inch knife who ran out of his medication. Did Everard Walker require a lethal response? Or did 11 officers crowding into a small apartment create the very conditions that made a lethal outcome almost inevitable? The family's attorney asked it directly. How does it go from 2 social workers and 2 police officers to 11 officers barging into his house and killing him? That is not just a moral question. That is a legal and administrative question this city needs to answer. Third, the homicide ruling. The medical examiner ruled Everard Walker's death a homicide. I need you to understand what that means legally, because people confuse this constantly. A homicide ruling classifies the manner of death one human being caused the death of another. It is not an automatic criminal charge, but it keeps the door open. The Inspector General still has to decide whether to refer this case for prosecution. That ruling is a foundation, and the family's legal team is building on it. Fourth, Connecticut's Police Accountability Act. This is one of the strongest police accountability laws in the country. It allows civil lawsuits against individual officers and against municipalities for excessive force or constitutional violations. This matters because of qualified immunity, the federal doctrine that has historically made it nearly impossible to sue police officers in federal court. Connecticut's law creates a state-level pathway around that barrier. The Walker family does not have to clear the impossible federal bar. That is a tool, and they are using it. Now let me zoom out, because what happened to Everard Walker did not happen in isolation. 8 days after he was killed, 8 days Hartford police responded to another mental health call. Another black man, another family that called for help. His name was Stephen Jones, 55 years old. Officer Joseph Magnano arrived on the scene, and within 30 seconds, he opened fire. 9 shots. Jones died. 2 black men. 2 mental health calls. 2 families who asked for help, 11 days apart. The pattern is not a coincidence. The pattern is the system. The community said enough. Organizations across Hartford made 5 demands of the mayor and police chief: a public briefing, termination of the officers involved, the Inspector General investigation completed within 6 months, permanent mental health crisis funding, and full activation of the Police Accountability Review Board. Mayor Arulampalam issued a statement about transparency and accountability. He did not commit to the briefing. He did not commit to firing the officers. He did not commit to the review board. Officer Magnano, who shot Stephen Jones, was eventually fired. Officer Clifford, who shot Everard Walker, remained on duty. The difference in how the same administration handled these 2 cases tells you something. Sit with that. Both men killed were black. Both families called the system designed to help them. Both were met with bullets. This is not feelings. This is history. This is a community that still had the faith to call 211 to try to do things right and still lost their father, their husband, their healer. How does a 211 call end up in a barrage of bullets? Who is going to trust 211? Who is going to trust the system when the system keeps doing this? The vigil was held 2 weeks after the shooting. His daughter said, "Hartford police won't walk me down the aisle at my wedding." His brother said, "What happened in that apartment leaves us with more questions than answers." And Linda Gray, 29 years, 6 children, a life built together, looked into a camera and said 3 words: "He killed my husband." That is all she had left to give. Here is where we land. Everard Walker did not die because he was a danger to this city. He died because a system that was supposed to protect him failed him at every single turn. It failed him when police were sent on a call that should have been handled without them. It failed him when 2 officers became 11. It failed him when a man in mental health crisis, holding a small knife, was met with lethal force instead of the patience that had already been working for almost an hour. And it failed him because he was black in America, where calling for help has never been a guarantee of receiving it. The family followed the rules. They called the right number. They said he was not dangerous. They were present. They were trying. And it still was not enough. Say his name: Everard Walker. Father, partner, healer, 53 years old. He deserved a doctor. He deserved care. He deserved to watch his daughter walk down that aisle. He deserved to come home. If this video moved, you share it. Drop your thoughts in the comments. And if you are new here, subscribe, because this is what we do. Every single week, we make sure these stories do not disappear. I will see you in the next one.
Let her come through. No.
Shut the fuck up.
No. Because he put his hands on me, so I'm not shutting up. Don't.
That's what happened.
Okay. Do you have anything illegal in the car?
No.
Okay. You don't have any crack?
I don't.
Weed?
Sir, I'm a fucking business owner, okay?
Okay.
I don't have no crack. I don't have no weed. I don't sell drugs, do drugs, no none of that bullshit. It's not a question.
It was a question.
That's very derogatory for you to say. Probably because I'm black. He was a black man,
I already
and y'all
told you
think
that
that it looked like we were selling drugs. No, because I'm highly upset that I feel offended.
Upset.
I would like it too. There you go.
Bianca, are you still living on Allen View?
Yes.
Okay. What were you doing over in New Cumberland right over there?
Dropping my son off.
Okay. What'd you hand off to the gentleman that walked back in the house?
His coffee cup.
His coffee cup?
Yes. I'm tired of him leaving his mess in my car.
Okay. All right. Do you have anything illegal in the car?
You want to search it?
I mean, if you want to let me search it.
Like, what do y'all think we did a transaction or something?
Well, that's what it looked like.
Because we're black?
No. I couldn't see in your car. Your window tints too dark.
Okay,
anyway.
so exactly. So, but it looked like we were doing a drug transaction.
Yeah, so you pulled up, he came out, you handed something to him, he walked back in the house.
You missed it.
We're not going to argue about it.
I came from this way, went around, took him home,
I saw where
dropped
you came
him
from.
off.
I saw where you came from.
And I dropped him off to his house.
Okay.
He left his cup here because I'm tired of his shit being in my car. I beeped the horn, gave him his cup.
Okay.
That's what happened.
Okay. Do you have anything illegal in the car?
No.
Okay. You don't have any crack?
I don't.
Weed?
Sir, I'm a fucking business owner, okay?
Okay.
I don't have no crack. I don't have no weed. I don't sell drugs, do drugs, no none of that bullshit. It's not a question.
It was a question.
That's very derogatory for you to say. Probably because I'm black. He was a black man, and y'all think that it looked like we were selling drugs. No, because I'm highly upset that I feel offended.
Upset.
I know. Come on, what we doing here? What we doing?
Would you be willing to let me search your car?
No. For what?
Well, because it looked like you did a drug transaction back
I gave him a coffee cup.
Okay. What kind of coffee cup?
It was a white fucking coffee cup.
Why are you screaming?
Because I can't believe because you keep saying that we made a drug transaction.
And that's what it looked like. Okay?
Wow.
It's simple questions.
It isn't, sir. That's not fair. That's not fair.
It's not fair. I'm sorry.
I know, and you police officers are horrible.
I'm horrible.
You police officers, sir. What we going to do, sir?
So now you're grouping me into a group of people,
and you're grouping me into a group of people where it looked like I was doing a drug transaction.
You could have been Mexican. You could have been white. You could have been green. You could have been yellow.
And I'm black, and it looked like that I was making a drug transaction.
Okay. All right.
And now you being a police officer, you people are horrible.
10-4. 10-4. So you don't have anything in the car?
Sir, I don't have nothing in my car.
What's the name of the gentleman that you stopped with?
That's my son, Anthony.
The bigger guy?
Yes.
That's your son?
I'm 55 fucking years old. I'll be 56 in February. What we doing here, sir?
I'm asking questions. I'm doing my job.
Okay.
All right.
And you going to do what you need to do with that?
His name's Anthony?
Yes. Are you going to do what you're going to do with that?
I am. What's his last name?
I can't believe it. Hold on.
On January 15th, 2026, a 5-year-old black businesswoman in Fairview Township, Pennsylvania, handed her son a coffee cup he forgot in her car. A police officer watched it happen. And his first instinct was crack cocaine. You don't have any crack? That is what he said to her. Not marijuana, not any substances. Crack. And she was recording the whole thing. That afternoon, Bianca Tatum had dropped her son Anthony off at his house, noticed he left his coffee cup behind, circled back, beeped her horn, handed it to him through the window, and drove off. A 30-second errand. Something millions of people do every single day. By the time it was over, she had been pulled over, interrogated, accused of running a drug transaction, and asked whether she was carrying crack cocaine. The officer faced no consequences. The video went viral, and now we are going to walk through exactly what happened. Before we go further, this channel exists for stories like this one. Stories about black people living their lives who get treated like suspects. If that is the kind of truth your feed has been missing, subscribe right now and turn on notifications. Because this story, like most of them, does not end here. Fairview Township is a quiet suburban community in Cumberland County, Pennsylvania. The kind of place where people expect ordinary days to stay ordinary. Bianca Tatum is a five-year-old black businesswoman and mother. On the afternoon in question, she had driven her son Anthony to his house, dropped him off, and noticed he had left his coffee cup in her car. She was tired of him leaving his things behind. She said so herself on the recording. So she turned around, beeped her horn, he came back out, she handed him the cup, and she drove away. 2 police officers were watching. One was Officer Lucas Alexander of the Fairview Township Police Department. The other was Agent Edwards, a drug task force agent with the Attorney General's office. What they believed they had just witnessed would set the next several minutes on fire. Officer Alexander pulled Bianca over almost immediately, and the first thing worth noting is that he already knew who she was. His opening question was not, "Can I see your license?" It was, "Are you still living on Allen View?" He knew her name, he knew her address. He approached this stop with existing information about this woman. He then asked what she had handed the man who walked back into the house. She told him plainly, his coffee cup. She was tired of him leaving his things in her car. Simple, clear, completely ordinary. The officer's next question was whether she had anything illegal in the vehicle. Not, "Can you explain what just happened?" Not, "I just want to confirm what I saw." Straight to, "Do you have anything illegal?" She offered to let him search the car. And then she asked the obvious question, "What did you think we were doing? A transaction or something?" His answer was, "Yes, that is what it looked like." She told him the reason it looked that way to him. "Because we are black." He denied it. He said he could not see into her car because it was too dark. And here is where you need to stop and sit with that for a moment. He admits he could not see what was being handed over. He could not make out what it was. And yet he pulled her over. And yet his next question was about crack cocaine, not marijuana. Not a general question about substances. Crack. He went straight to crack. Bianca told him she was a business owner. She does not do drugs, does not sell drugs, none of it. He kept pressing. He asked again if she would let him search the car. She said no. He kept insisting it looked like a drug transaction. She kept telling him it was a coffee cup. Then came the moment that the officer cannot walk back. When she told him that Anthony was her son, he responded, "The bigger guy? That's your son?" The surprise in that question is not subtle. He looked at a tall black man and could not connect him to this woman as her child. He looked at them and saw something other than a mother and son. He told her she did not look old enough. She told him she was 55 years old and would be 56 inches February. She never stopped pushing back. She told him directly, "You are grouping me into a category because I am black." He offered her the deflection that has become almost a script at this point. You could have been Mexican, white, green, yellow. He listed colors that do not exist as skin tones to argue he does not see race. She was not moved, and she should not have been. The word crack is the turning point of this entire encounter. Not because it is the most dramatic moment, but because it is the most revealing one. When an officer cannot see what is being exchanged, when he admits visibility was the issue, the word he reaches for tells you what assumption was already sitting in his mind before he even approached the car. He did not say, "I could not tell what it was." He did not say, "It looked like an exchange of some kind." He said, "Crack," specifically, immediately. That word did not come from what he observed. It came from what he assumed. And what he assumed was shaped by who he was looking at. No drugs were found. No charges were filed. Bianca Tatum was free to go. But free to go is not the same as unharmed. She drove away having been publicly accused of selling crack cocaine to her own son. She drove away having had to defend her identity, her profession, her family, and her basic dignity on the side of a road in her own community. And her son Anthony, the bigger guy, stood there and watched his mother be treated like a criminal for handing him a cup of coffee. That is what she walked away with. Here is the constitutional question at the center of this stop. The Fourth Amendment does not bend for suspicion that makes someone uncomfortable. It requires reasonable suspicion, specific, articulable facts that a crime is taking place. Not a feeling. Not an assumption. Facts. The officer's own words undermine his own justification. He said he could not see into the car. He said it was too dark, which means he did not have specific articulable facts. He had a hunch, and that hunch was dressed up as police work. Bianca exercised her rights correctly. She declined to consent to a vehicle search. She declined to provide her son's last name. She was not legally required to do either. And critically, no evidence was found and no charges were filed. That absence speaks loudly about what the legal basis for that stop actually was. Officer Lucas Alexander was sworn into the Fairview Township Police Department on October 14, 2025. That means this encounter happened less than 3 months into his time at this department. He had come from a different department where he had served for 2 years. As of Bianca's most recent public update, she had reached out to Fairview Township, but had not yet been able to speak to the appropriate person. She described the process of following proper steps while making clear she had no intention of letting this go quietly. There has been no public statement from the Fairview Township Police Department addressing the substance of her complaint. No acknowledgement, no accountability. Not yet. Let us be direct about what this stop fits into. A black mother and her adult son. A hand-to-hand exchange the officer admits he could not see clearly. The immediate leap to crack cocaine. The surprise that a large black man could be someone's son. The dismissal of her explanation even after she gave it clearly and calmly. The "you could have been green, you could have been yellow" deflection when she named race directly. This is a pattern. It is documented. It is consistent. Black women are routinely treated as suspects in the spaces of their own ordinary lives, in their cars, in their neighborhoods, running errands that would not raise a single eyebrow if they look different. The narrative of suspicion follows them into moments that should be invisible. Handing your son a coffee cup should be invisible. It was not invisible for Bianca Tatum. Bianca Tatum has been clear. She is taking this to the highest level she can reach. She is following the proper steps. She is not letting up. The video has been seen by hundreds of thousands of people. The officers have been identified. The department has been put on notice. What happens next depends on whether the systems that are supposed to provide accountability actually function the way they are supposed to. This channel will bring updates as they come. Bianca Tatum was running an errand. She handed her son a coffee cup. She drove away. That is the entirety of what she did. What was done to her in return was that an officer who admitted he could not see what was in her hand decided the word for it was crack. And when she told him exactly why that assumption landed the way it did, he offered her green and yellow as proof that race had nothing to do with it. She did not accept that. And neither should we. This channel does not tell you what to believe, but it will always tell you what happened. And what happened here is that a black woman in Pennsylvania was made to defend her humanity on the side of a road for handing her son a cup of coffee. That has a name. And that name is not doing his job. If this story moved you, share it. Subscribe. Drop your thoughts in the comments. Silence is how these things get buried, and this one deserves to be heard.